Hello everyone, I'm George from Ireland. So this is going to be a quick video about the rule of law in English law. So there's some debate as to whether it's a formal concept or a substantive one. Now Dicey, who I've mentioned in previous lectures, he had a particular theory about what it is, and Lord Bingham, who died only about 10 years ago, he moved on from that. So this is the creative tension that we've got to bear in mind. Come back to both of those in time. Dicey's theory versus Lord Bingham's theory. Dicey died 98 years ago, so Lord Bingham articulates what's more broadly accepted these days. So the rule of law, well, it's partly that no one is above the law, and indeed that includes the monarch. She is constrained by the law and she's accountable under law. And the judiciary, they are deferential to the legislature. The judiciary are also independent. It's possible that these two things collide. Are they overly deferential to the legislature, or they be more independent, be more assertive of what they can do? So the rule of law is something that more or less everybody agrees exists, but there's spirited debate about what exactly it is. So Judith Schklar said it's a self-congratulatory rhetorical device. If you read the book The Rule of Law by the late Lord Bingham of happy and glorious memory, he said the trouble is it's come to mean hurrah for our side. So he dives into it he dives into it in greater depth about restrictions on what various organs of the state can do. So the Constitutional Reform Act of 2005 said that there is a constitutional principle of the rule of law. I don't think many people would doubt that. But what's the context of this? We have to ask in each case. What is the law preventing you from doing, or indeed obliging you to do? And how is it applied? How does it apply to judges? Well, courts can overrule courts. Nobody can overrule the Supreme Court, but Parliament can pass an act which would trump a Supreme Court decision. Now we know that the judiciary is independent with the Judicial Appointments Commission, but Parliament could change that and say, well, the Prime Minister has total control of the judiciary. So would that be allowed? Presumably it would. So there are certain contradictions in this whole idea of the rule of law. So judicial review, remember, is a process whereby decisions of the executive can be challenged and could be ruled to be illegal. And so that's how the rule of law operates. So John Adams, one of the founding fathers of the United States, indeed the second president, in his thoughts on government, he said that the United States was an empire of laws and not of men. Okay. It makes me think of the biblical statement that men were made for laws. So laws are made for men and not men for laws. That we mustn't be too legalistic about things. For someone who's fascinated by law, it might seem to be an odd criticism that you should be legalistic. But as you may have noticed, the law is more flexible than you might have first imagined. When I started studying law, I thought it would all be so clear-cut. The very word law suggested to me certainty and consistency. I see quite often it's only possibly and probably and things like that. And there are grey areas in law quite a lot. And you see how things are contentious a lot of the time, that the actual position is not obvious. Anyway, what did Professor DeSmith say about it? He said, powers exercised by politicians must have legitimate foundation based on authority conferred by law. So there's a limit to what they can do. They can't just claim we can do absolutely anything. So there's those who say it's formal. Well, Joseph Raz was one of those. They would argue that there's clarity and certainty, the rule of law, and it's prospective, not retrospective, as it's looking forward, not looking backwards. And it requires people to have proper authority for their actions. So the organs of the state have their power trammelled by law, and it does provide consistency. Here I'm dubious that he's accurate in saying that, and that law is morally neutral. Well, again, that's debatable. Some laws are good, some laws are bad. What's moral, what is immoral? Again, that's something which is hotly contested. And some things are amoral. How high should a speeding fine be? £40, £45? I don't think it's quite a moral question that. If it was to be a penny versus £1 zillion, then you might get into the realms of morality. But some of what he said, I think, is disputable. So you ought to dip into The Rule of Law and Its Virtue in 1977. That's by Raz. Now, those who say that rule of law is substantial, say there's formalism plus X. Well, look at Ronald Dworkin, and he has a rights conception of the rule of law. So another great scholar of jurisprudence, Jowl, said there's a principle of institutional morality, claims that law is not morally neutral. Or Lord Bingham in 2006, one of his most celebrated lectures, not long before he passed away, said that the rule of law is about the protection of human rights. But we had the rule of law when things were done which we now regard to be completely inimical to human rights, when our own species was treated as a commodity to be trafficked, when the death penalty was imposed for trifling offences, when there was no law against torture, when wife beating was held by courts to be legal, and so on. When what we now regard as paedophilia was completely lawful. So when racially discriminatory legislation was on the statute book. So it's contestable. Maybe these days it upholds human rights, but certainly in the United Kingdom, human rights as we understood them have only been around even as a concept for a bit over 200 years, and not in law in most instances until into the 19th century. Okay, so coming back to Albert Venn Dicey, that Vinerian professor of public law in Oxford University, you ought to read his law, the Constitution. And he said that rule of law is about the avoidance of arbitrary power, not to grant excessive discretion to the executive in particular, or indeed to judges. They too need to be limited in what they can do. So he believed in equality before the law, despite being an advocate of the hereditary peers having a place in the legislature and indeed being able to block legislation permanently. So he was a conservative in politics, as you might not be surprised to learn. He claimed that there were common law constitutional rules in the rights, and these had been decided by courts down the centuries. So onto Bingham. Lord Bingham said that we must have accessibility of law, access to justice, and we've had that since the Second World War, legal aid. But there have been cutbacks, and some people doubt that there really is enough access to justice. The trouble is, they say the courts are open to everyone, just like the writs, open if you can pay. But of course, if you're an adult of sound mind, you are entitled to represent yourself in court. But what if you're not an adult or not of sound mind, and there's not enough legal aid? Well, then you're stuffed. But even as a mature person who's compos mentis, there's no equality of arms. You up against a very sharp barrister with a team of solicitors, you wouldn't stand a chance. And isn't that another problem? That if they've got the stellar brains on their side and you don't, you've got some old dolt of a lawyer paid for by the taxpayer with a little the government can get away with paying, come on, who's going to win? Now, you're not absolutely certain, but isn't it very likely that the stronger legal team is going to win, regardless of the justice in the case? Because why would people be paying top fees to lawyers if they didn't think it was an advantage, if they didn't help them quite as part of the actual fairness of the issue, or the actual legality of the issue? That's another thing. Surely that's unfair too. And if we're to really have a level playing field, maybe you shouldn't be allowed to pay fees, and barristers and solicitors should all be paid by the state, all paid the same, so that the rich can't buy an advantage in court, can't buy a better chance of getting what they want in court, even if that's unjust. So there are other principles. Law, not discretion. We mustn't leave it up to the whim of one person. Remember the old days of absolute monarchy, all about fiat. Let there be, let it be done, according to the Latin word fiat. So there's dispute resolution through law. Equality before the law, right? So we're all accountable, and we mustn't have discrimination. But you see areas where there's positive discrimination. Is that fair? Or women getting lower pension ages, or even age discrimination? Children getting greater rights in some areas, but fewer rights in other. Greater protection, but not allowed to do this and that. So that's not complete equality. This notion of equality is rather relative. So rule of law is to ensure that there is proper exercise of power, that it's not abused for selfish or personal or immoral ends. You have a right to fair trial. That's another principle of the rule of law. There's presumption of innocence, and a jury which is unbiased, or a judiciary is unbiased. How do we know the judiciary is unbiased? By the way, and if you're in the Labour Party and the judge is a Tory, how do you know she's not going to be biased against you? She might, and that wouldn't be a reason to her to recuse herself. So all this is very arguable. And also respect for international law is meant to be there. And incidentally, in that book, The Rule of Law by Lord Tom Bingham, he lambasts the United Kingdom, Blair's government, for leading the UK to war over Iraq, claiming it was illegal, though he rehashes the case for the liberation of Iraq, though he says he disagrees with it. All right, he said it was a serious violation of international law. Coming on to the accessibility of law, we need to be clear about this. There was an example, a key case here, the Sunday Times and the United Kingdom in 1979. And it was found that accessibility to justice was prescribed by law, according to the European Convention on Human Rights, Article 10. There's another important case about this, Shaw and the Department for Public Prosecutions, 1962. So another issue is that laws are not to be retrospective. What I'm doing something today, if they pass a law tomorrow saying that wearing a blue shirt is a crime, I can't be punished for doing it because I wore that blue shirt before it became a crime. Remember, that's R&R 1991. Or the War Damages Act likewise. The War Crimes Act 1992 to prosecute people for things they'd done in realms outside the United Kingdom in the Second World War. No, you can't do that. You can't. That'd be retroactive. Or the Job Seekers Back to Work Act 2013. All right. So law means we're not using discretion so much. So discretionary power, the trouble is that's so arbitrary. It's up to the whim of the individual. And we don't know what the law is then. This is what Professor Dicey had to say about it. When Voltaire came to England, his predominant sentiment was clearly that he had passed out of the realm of despotism to a land where laws may be harsh, but where men are ruled by law and not by caprice, because it was just all so whimsical. Whatever you feel like, if you're the one who's wielding this unlimited power. Remember, Voltaire was an early 18th century French philosopher who came to England, surprisingly was deeply oppressed by it, and actually learnt English. About the only 18th century Frenchman to speak English. Most Frenchmen were likely to look upon the island where England is as barbaric. So the rule of law is about limiting or even abolishing discretionary power. But doesn't the executive need a bit of discretion, a bit of individual choice, elections used to be called at the whim of the Prime Minister, or the Prime Minister to have confidence in ministers, promote and demote and so on. That's some sort of discretion. And we have to have a human aspect. Judges exercise discretion too. It's not absolutely clear-cut. In the magistrate's court, this magistrate would have declared you guilty, another might have declared you not guilty. They are human. There's a bit of variety between them and their personality types. So there is great complexity in modern governance. The state intervenes in our life a great deal more, and perhaps that's why there's a need to limit discretion as much as humanly possible. Read von Hayek, The Road to Serfdom, and he said that this would be the problem. All right, so Loveland said it's an issue of the red light versus the green light. So come on to equality before law. So there are a few exceptions to this, which is Crown immunity in certain areas, but doesn't that do violence to the very notion of equality before law? Or members of Parliament have privileges, for example, absolute privilege in Parliament to say things which would be libelous if said elsewhere, to say that someone committed an imprisonable offence, or to say that someone is incompetent in his or her job and so on, and they can't be sued for that. And then qualified privilege for the press corps to report this so long as they do so in good faith and accurately. Okay. So judges, they're immune from a lawsuit. You can't sue them for getting the decision wrong. Even if it can be found they erred in law and the decision is overturned, they can't be sued for incompetence. Perhaps that's unfair. So how come, if there's equality before law, it doesn't apply to judges? Lord Bingham, you can't answer from beyond the grave. There's diplomatic immunity. A diplomat, if arrested, must be unhanded as soon as you know he is a diplomat. No searches on their things. So again, that's an exemption. But is that the exception that proves the rule, or that really proves the rule to be a fallacy? Or there's M and Home Office, 1993, another example of equality before law. So we're supposed to have the proper exercise of power. Government action has a bearing on what individuals do. So authorization for this action is required. There was a case called Entink and Carrington in 1765. Carrington, that politician, that draper from Nottingham, who later was enabled by Pitt the Elder. He said, and this is Lord Camden said in this case, he is bound to show by way of justification that some positive law has empowered him. Okay, so ministers of the Crown can't do whatever they want. There must be some law actually saying that you have this competence to do this, you are permitted to do this. Okay, another case, ex parte viewings, a 1995 case. This is what a judge called Laws said. Yes, his surname was Laws. Action to be taken must be justified by a positive law, actually granting this rightful authority to do such and such. Now, judicial review, remember, this is the court examining whether an action by the executive was lawful or not. The action should be within the competence of that body. It must not be ultra vires, as in they're exceeding their authority. It must be for a proper purpose. They must have acted in good faith, not for some malicious or self-interested reason. They must have acted fairly and indeed reasonably. Quite a high test to pass. Okay, they've got to have fair legal process. There must be access to justice. But, it's been cut back in the last 10 years under Cameron, May and Johnson. David Cameron's brother, barrister, even going on strike over this. With the right to a fair trial under the European Convention of Human Rights, Article 6. That's been around for a millennium. There must be fair legal procedures. Ample time to prepare your case, a hearing, qualified lawyers offered to you, legal counsel, the right to refuse legal counsel, sack your legal team, rules of evidence, documents and exhibits shown to both sides, and things like that. An impartial hearing, and all the rest of it. A right to appeal. So the judiciary is not supposed to be partisan. How can we be sure that's true? I think we just take that and trust a bit too much. There was a case about that, McGonigal and the United Kingdom, bailiff of Guernsey. Guernsey is an island in the English Channel. It's not part of the United Kingdom, but it's connected to the United Kingdom politically. The Queen's their head of state. Their passports say United Kingdom, brackets, bailiwick of Guernsey. Bailiwick being like the name for that political entity. So they use a blend of English law and a bit of Roman law, speaking Guernseyese. Some of their courts, some of their exams are in that. Okay, there's our Unison and Lord Chancellor, a 2017 case before the Supreme Court. And it said that the fees order of 2013 had to be looked at. The fees imposed for claims by the Employment Tribunal were excessive. Lord Reid said the constitutional right of access to the courts is inherent in the rule of law, and you mustn't make these courts effectively inaccessible. So what's the judicial approach here? They're supposed to guard the rule of law. Anyway, that's according to the separation of powers. So judiciary, how deferential should it be? Well, Liversbridge and Anderson in 1942 examined this very issue. There are other leading cases about it, ex parte Hossenball in 1977, and indeed ex parte Cheblak in 1991. So think about human rights, about A and others against the Secretary of State for the Home Department in 2014 about them being mistreated in prison. So there is a limit to what the Secretary of State can order. So the current law, the rule of law, what is the situation right now? Well, there's an important case, R, Corner House Research, and the director of the Serious Fraud Office in 2008, showing that the rule of law is expanding its scope, or R, Bingham Mohammed and the Foreign and Commonwealth Office 2010, about an allegedly corrupt deal in the Middle East, or Rahmatullah and the Foreign and Commonwealth Office 2002. So it's all in flux, it's all changing the rule of law. Anyway, we have to ask whether the UK Constitution is balanced. It would appear to be that the rule of law collides with parliamentary sovereignty. They're not completely incompatible, but the frontier between them is again unclear. There was Jackson and the Attorney General in 2005. What did Lord Hope say in this case? He said the rule of law is enforced by the courts, and that's the ultimate controlling factor on which our Constitution is based. So not surprising the judge thinking that judges were terribly important. Anyway, so Geoffrey Jowl, in Changing the Constitution, he's a famous legal scholar, he had this to say about it. Britain is moving steadily to a model of democracy that limits governmental power in certain areas. even where the majority may prefer otherwise. The rule of law supplies the foundations of this new model. Should it be that way? Again, it's contestable. Maybe the judges have arrogated excessive power to themselves. We can't assume that they're always wise, intelligent, benevolent of all that. They may be pushing their own agenda consciously or unconsciously. Are they necessarily more trustworthy than Parliament? They might be. I think it's unlikely. There are obviously deficiencies in both systems. But that's one of the important things why it's a balance, why no one organ of the state is to be overmighty. Well, that is my penny's worth on the rule of law. Toodaloo.